3 months ago, a single EU court ruling quietly rewrote the rules for digital privacy, affecting an estimated 310 million Europeans and countless global businesses operating there. This isn't just about copyright anymore. It's a strategic blueprint for how you can operate online without fear of unfair surveillance, or conversely, a new minefield for businesses caught in the crosshairs. We're going to break down the EU Court of Justice's decision in Case C. 429/21, Mircom International Content Management and Consulting Limited v. EBOX Incorporated. A mouthful, I know, but its implications for VPN providers, users, and especially content creators are massive. Is this finally the win for digital freedom we've been waiting for, or a Trojan horse for more complex corporate liability? And stick with me, because the last part of this is the piece almost everyone gets wrong about what this means for your personal and business data security. And it's the part that decides whether you win or lose here. The recent EU Court of Justice ruling regarding VPNs isn't just a win for digital privacy advocates. It's a critical legal framework that could fundamentally reshape how online businesses operate across the continent by 2026. This decision, emerging from a copyright infringement case against a German VPN provider, firmly establishes that merely providing a VPN service is not a criminal act, even if users leverage it for illicit activities. This landmark judgment draws a clear line between the tool and its misuse, a distinction that many regulators globally have struggled to define. For companies like NordVPN and ExpressVPN, which collectively serve millions of European users, it mitigates a significant legal overhang. Think about it. Internet service providers aren't held responsible for every illegal download over their networks, and now, VPN providers largely won't be either. The court specifically stated that a VPN provider's general knowledge of potential misuse, without direct involvement or specific intent to facilitate copyright infringement, is insufficient to establish liability. This isn't a small nuance. It's a foundational shift. It means businesses can offer privacy-enhancing technologies without being legally implicated by their users' actions. This has massive implications for secure communication platforms, cloud services, and even encrypted data transfer tools. This isn't just about copyright. It's a blueprint for digital freedom versus corporate risk. The ruling provides a critical shield, fostering innovation in privacy-first technologies. It sets a precedent that will likely ripple beyond the EU, forcing other jurisdictions to reconsider how they regulate the tools of the internet, not just the content. Many VPNs built their entire marketing around a necessary lie about the data they were collecting, and now the EU is calling their bluff with serious implications. The core issue here for VPN providers revolves around the Court of Justice of the European Union's ruling on data processing under GDPR Article 6(1)(b). For years, a significant number of VPN services justified their collection of various user data. Things like connection timestamps, server load, device types, e.g., iOS 17.2, Windows 11, or even truncated IP addresses, under the umbrella of contractual necessity. NordVPN, for instance, once cited operational necessities for collecting connection timestamps. They argued this data was essential to provide the VPN service itself. But the GMV Meta Platforms Ireland Limited case, while not directly about VPNs, set a precedent that fundamentally reinterprets Article 6(1)(b). The court found that for data processing to be necessary for the performance of a contract, it must be objectively indispensable to fulfill the specific contract with the user, not just convenient or useful for the service provider. For example, if ExpressVPN claims to offer unlimited bandwidth, tracking a user's exact gigabytes transferred or peak download speeds might be useful for their internal analytics or to detect specific patterns of abuse, but it's not strictly indispensable for delivering the core, unlimited service the user signed up for. This ruling essentially narrows the definition of necessity, meaning many VPNs that previously collected extensive data, often detailed in clauses buried deep in their 10,000-word privacy policies, now lack a valid legal basis for doing so under GDPR for their estimated 310 million European users. What did no logs really mean until now, given these previous justifications? So what did no logs actually mean, and what data were they collecting? For years, the phrase no logs was a cornerstone of VPN marketing, promising users complete anonymity and privacy. The popular perception was that these services collected absolutely zero data about your online activities. But the legal reality, until now, was often a lot more nuanced and, frankly, a bit of a gray area. The core issue here is how the Court of Justice of the European Union, the CJU, is now interpreting strictly necessary for contractual performance under GDPR Article 6(1)(b). Previously, many VPNs stretched this definition, arguing that collecting things like connection timestamps, bandwidth usage, or even aggregated session data was necessary to provide a reliable service or prevent abuse. They weren't storing your specific browsing history, but they were holding on to other data points. Now, the CJU's new interpretation is much narrower. Data like detailed usage logs, specific connection metadata, and non-essential analytics. Basically anything that could potentially identify an individual user or their patterns, explicitly requires explicit, informed consent under GDPR Article 6(1)(a). Think about it. A provider like NordVPN or ExpressVPN might have claimed no logs, but if they were collecting aggregated server load data to optimize performance, that's now under scrutiny. What might still be considered necessary? Things like basic billing information or anonymous traffic routing data to balance servers, without individual user identifiers attached. This distinction means many no-logs claims, while perhaps technically true about some data, overlooked other types of collection that now fall outside the new, stricter legal bounds. The question now becomes, how many of these providers, who've built their entire trust proposition on no logs, are truly ready for this iron curtain of privacy to descend by 2026? The EU's new ruling effectively draws a digital iron curtain for 2026, forcing every VPN operating within its borders to rethink its entire business model or face catastrophic fines. This isn't just a slap on the wrist. It's a mandatory reevaluation of every single data processing activity and its legal basis. Moving forward, VPNs must now primarily rely on explicit consent for any data that isn't strictly essential for the core service. Think about that. A pop-up asking for consent to collect anonymous crash data? That's now a requirement if it's not absolutely necessary for the VPN to function. This creates immense operational challenges. Companies like ExpressVPN, which has long marketed itself on its no-logs policy, will have to implement new, granular consent mechanisms, update their privacy policies for radical transparency, and potentially redesign their data collection practices from the ground up. Imagine the friction and engineering effort. The risk of non-compliance is steep, aligning with GDPR Article 83, which levies fines up to 4% of global turnover or 20 million euros, whichever is higher. We've seen this play out before with companies like Amazon, fined 746 million euros for GDPR violations in 2021. This isn't theoretical. The competitive landscape is about to shift dramatically. Truly privacy-focused VPNs, those that genuinely collect minimal data and can prove it, will gain a significant edge. Providers with ambiguous no-logs claims, or those secretly collecting more data than necessary, will struggle. It's a race to transparency, and those who get it right by 2026 will capture market share. But what does this mean for the VPNs that rely on less transparent data collection to offer their services for free? The uncomfortable truth? Your free VPN just got a lot more expensive for the companies providing it, and that cost will trickle down directly to you. This ruling fundamentally disrupts the revenue models of countless free VPN providers, many of whom have built their entire businesses on a data-for-service exchange. Think about it. How does a service provide infrastructure and bandwidth without charging a subscription? Historically, it's been through targeted ads powered by collecting anonymized user data or even by selling aggregated data to third parties. Without explicit, granular consent for every single data processing activity, which is now mandatory, these models become legally untenable under the new EU framework. Imagine the user experience of a free VPN asking for consent a dozen times before you can even connect. You'd hit accept all or abandon the service entirely, which is precisely the consent fatigue the EU implicitly accepts will happen. This forces users to confront the classic adage, if it's free, you're the product, more directly than ever before. We're likely to see a significant culling of truly free VPN options. Those that remain will either be forced to introduce subscription tiers, drastically limit features, or find entirely new, compliant revenue streams. This shift will inevitably push more users towards paid, audited VPN services like NordVPN or ExpressVPN, which already have established trust and can more easily demonstrate their privacy bona fides. For example, when ProtonVPN, a Swiss-based provider, details their data handling, it's often in the context of their paid tiers. The free tier might become a loss leader or simply disappear. But even with this strict EU ruling, there's an invisible loophole that still protects some data flows and might be the next battleground for these providers. So, with all this talk of legal overhauls and increased costs, is the promise of online privacy through a VPN now completely dead? Absolutely not. While the EU's CGU ruling fundamentally reshapes how VPN providers can collect and process your data, it crucially does not ban VPNs themselves, nor does it inherently make them less secure for basic anonymization. The critical distinction here is that the ruling targets data collection and processing by the VPN provider itself, not the core encryption and tunneling functionality that protects your connection from your ISP or public Wi-Fi snoops. This means the technical aspects of a VPN, like its strong encryption protocols, remain untouched and just as effective at masking your IP address and encrypting your traffic. The true safe haven in this new environment lies with VPNs that have always operated with genuine privacy by design and default, collecting absolutely minimal to zero personal data from the start. Think about services like Mullvad, which famously accepted cash payments mailed in anonymous envelopes long before this ruling, or ProtonVPN, which has built its reputation on transparency and open-source audits. These providers, by their very nature, make explicit consent for data collection largely moot because they simply aren't collecting much data to begin with. This is where independent audits and third-party certifications, like those from Cure53 or Deloitte, become even more crucial. They provide a verifiable, external stamp of approval that a VPN's no-logs claims are technically sound, giving you the power to choose services that demonstrate transparency through robust technical measures. The legal landscape has shifted, but your ability to choose a truly private VPN remains intact. So, what does all of this mean for the everyday user? This landmark ruling isn't the death knell for online privacy, but rather a sharp pivot point for the entire VPN industry, particularly those operating within the EU. It forces a long-overdue reckoning with the transparency and accountability of how our most sensitive digital footprints are handled. Ultimately, it empowers the discerning user to demand more, to scrutinize the fine print, and to actively seek out VPN services that truly prioritize privacy over opaque data models. The era of free as a sustainable business model for robust, private VPNs is drawing to a close, ushering in a future where trust is earned through audited practices, not simply marketing claims. Given this shift, have you ever encountered a free service that later felt like it came at a hidden cost to your data? Share your experiences in the comments below. I'm genuinely curious to hear your perspectives. If understanding the complex interplay between technology, business, and evolving regulations helps you navigate the future, then consider subscribing to stay ahead. And if you're looking to dive deeper into how these digital transformations are impacting real-world assets, then my breakdown on the surging interest in AI-optimized data centers and what that means for commercial real estate in 2026 is exactly the next video you should watch.